be with you, and this hope will be seen as a sign of appreciation for this interesting initiative, which discusses the challenges raised by mobility of individuals at this moment of the International Tax Law Research Network. This is session 3, and the focus is now on the issues. You've been hearing sessions on policy. Now we are focusing on issues, and then there will be the challenges. I have the pleasure to chair this session with my Indian colleague and friend Mukesh Butani, who is in Belgrade with you. And it's also important that he and I will present possible different views. We live in different parts of the world, perhaps have a lot of common research interest and practical interest, but I think it's important that whatever event takes place, it is global. The right approach is not to discuss global issues among a group of people and then see whether they fit with the rest of the world. The right approach is to discuss them in an inclusive way. And this is what I expect to happen for the future. I congratulate Professor Kostić for this initiative and would like to make an efficient use of the time that is available. If we cannot make it to finish by 5:45 Central European summertime, I understand that there will be some slight tolerance, but I will try together with Mukesh to protect the last speakers, and I should say here the commentators. We have 4 presentations in this panel, and the 4 presentations will follow the order of naming the colleagues. The first one will be by Giorgio Beretta on the tax residence of individuals. I will then announce the title before introducing him. The second one will be by Svetislav Kostić on the employment income. The third one by Karolina Tetłak from the University of Warsaw. Giorgio Beretta is professor at the University of Amsterdam, and Svetislav Kostić, of course, at the host university in Belgrade. And the presentation by Karolina will be on taxation of assets and sportsmen, of course, all focus on tax treaties. And then we have the presentation on social security, which will be done by the 2 Slovenian colleagues, Professor GregaStrban and Professor Luka Mišič from the University of Ljubljana. There will be 2 commentators who are very well familiar, maybe to many of you, Marco Felder from Liechtenstein and Ignacio Gridilla from Spain. And as I said, I have the pleasure to chair this session together with Mukesh Butani, who is a BMR legal partner in India and a very well-known international tax member of, let's say, the community. Mukesh and I will be making some brief introduction in order not to abuse of our role of moderators, and that will be perhaps possibly helping the audience also to warm up and to hear the interesting things that will line up with our speakers. So I will try and be brief. The topic of international individual taxation and the issues connected with tax treaties is particularly important. The world is changing, the way of doing business is changing, but also the way in which individuals behave is changing, and we will see that in a few minutes. One of the points that is becoming increasingly clear is that international tax law requires some revamping or updating and adjusting of its structural features. So from this perspective, I think that the core issue to be discussed is whether tax nexus as such is fit to meet the challenges that will also be discussed in the remaining time of this conference. So the fact that there is serious research done in connection with this conference, I think is absolutely very welcome. And I say that also in my IBFD capacity. Now, I would like to say that when it comes to tax nexus, we have to understand that for a number of years, in particular for what we call active income, we have been using reasonably good proxies to determine the connection with the tax jurisdiction. And that goes from business to active income, and we'll be talking in particular about income from employment. But the world has changed, and so must international tax law, in order to avoid turning into a cage for the exercise of a taxing sovereignty. Some countries are perhaps not so interested in adjusting the current shape of tax nexus, but others are, because this is the only way to avoid seeing their taxing sovereignty eroded. I would say that since we all belong to this planet and we don't have a planet B, we should all be working together in order to find a fair and equitable tax nexus. So as soon as we realize that the current shape of allocation of taxing rights under tax treaties is no longer suitable to preserve these goals of fairness and equity, then we should do something about it. So this is important because, unfortunately, I cannot enjoy Belgrade with you, and I'm speaking remotely, but this says it all. There are a number of active, performances, or if you prefer, of situation which involve persons which can be done at distance now, and we have to make sure that when there is money involved in this, then states can exercise their sovereignty in a way that reflects the goals of fairness. I want to say that we saw this with the two pillars, that at a certain moment, the two pillars of the BEPS project, at a certain moment when some countries couldn't have their voice heard, they started going or revamping unilateralism. And this is why, coordination came in again to try and come with constructive solutions that could preserve this fairness. So in other words, if we're here all together, this is to try and discuss those specific issues related to active income mainly, but also to personal tax nexus, because Giorgio Beretta will address personal tax nexus as first speaker, and see how and to what extent we can find consensus on how we can change the existing rules. And of course, we want to address problems of tax treaties, not in a sort of secluded world, but in particular, when it comes to relations involving in employment, it is important also to see how taxing powers fit into the overall picture of what happens with social security. So this is perhaps the first time that we are in the tax community addressing this link many years after a conference that we organized in Vienna and that produced a book which was published on social security agreements and taxation. So that is to keep things to a bare minimum. As I said, all we are discussing today is verifying the legitimacy of tax nexus in light of the developments concerning international individual taxation and the way it should be. Now, as you know, I am co-chairing this session with Mukesh Butani, and I think it's important then, before handing over the microphone to the first colleague, who's going to be, as I said, Professor Giorgio Beretta, I hand over the microphone to Mukesh, so that Mukesh can also share with you his perception of the problems that we're going to discuss in this section. And then if you wish, Mukesh, you can hand over back to me. Thank you.
Thank you, Pascal. And it's a privilege and an honor for me to be here amongst all of you. I was jokingly mentioning to Pascal, had I known that he's not going to take the effort of traveling from Amsterdam to Belgrade, I would have really changed my mind. But I'm thankful that he didn't tell me that. I'm not going to steal the thrill away from the detailed research reports that have been put out by various people. We've had the opportunity in the last 5 to 6 days to share our thoughts. The issues in the part of the world that I come from are very, very different. I was particularly interested in the morning when one of the speakers spoke about the Bhagwati report, which talks about taxing the brain drain. What I instead would do, Pascal, is I would rather have the technical speakers present the paper, and subject to availability of time, I would come towards the end because I have some comments, particularly on social security from the part of the world that I come from. So without much ado, just hand it over to Greta.
Okay, so now we are having Giorgio Beretta, professor at the University of Amsterdam, making his presentation on should we rethink the tax residence of individuals? Giorgio, it's now 4:12, and you know about timing and that it is important to protect our colleagues who speak last. And of course, we're all eager to learn from you. Please go ahead.
Okay. Can you perhaps pull up the slide, please? Thank you. Not yet. Yes. Okay. Thank you very much. First of all, I want just to thank, well, good afternoon, everyone. First of all, I want just to thank the ITL Research Network for this invitation and for organizing the conference, and also the University of Belgrade. And also I want to thank Professor Pasquale Pistone and Mr. Butani for introducing and somehow also frame the debate. I think that this conference has two main underlying forces that are reshaping our world and, of course, are reshaping also our thinking about taxation. And they are, of course, digitalization and increased mobility of individuals. I think that actually those forces are not just parallel forces, are convergent forces. And that's why when the cocktail, so to speak, become explosive. Because when those two forces combine each other, they have a multiplying effect. And allow me to give you some, two scenarios actually. The first scenario is about virtual immigration. This is a word that was used by Financial Times columnist Martin Wolf, and he said that with the digitalization, actually people are able to not to move, but to connect and take up tasks and employment for every part in the world. At the same time, we have the possibility, increased possibility of mobility. With people can actually travel in many countries and also pursue employment tasks, not necessarily be connected with the employer, closer to the employer. So employee moving around the world, not necessarily, at close proximity with their employer. So I think those two tasks are challenging for a tax perspective, and I have analyzed those tasks with regard to particular taxation of employment income, so Article 15, but I do think that these challenges equally affect the concept of even more fundamental concept, so to speak, which is the concept of tax residence. Before, however, addressing those challenges, I would like to take a step back. So go back to International Tax 1.0. So what are actually the premises on which the concept of tax residence is born? On which premises is born? What are the foundation, or to use a common terminology, what are the pillars, on which the concept of tax residence is actually built? And Professor Pistone mentioned the concept of tax nexus. So residence essentially express a nexus between an individual and a jurisdiction. And this nexus is understood as a territorial nexus. So the idea to connect an individual with the territory of a defined countries. And this idea, we heard this morning about sociological, effect and even philosophical effect with the presentation of Peter Ongler, Professor Ongler. But I think that it goes back to the idea of, having individual having a sedentary lifestyle. So basically, since individuals from the Neolithic age, and we heard already Professor Kostić mentioning that, the concept of Neolithic age in his presentation this morning, we actually, since that Neolithic age, we have a mankind that is essentially static. So as a sedentary lifestyle, even perhaps a sedentary mindset. And we, as a tax, so I don't know, a tax advisor or tax policy office, actually built upon this concept of, a sedentary lifestyle and built the idea of economic allegiance. So the idea to connect, that an individual has some interest with some vested interest in a country, merely interest of economic type, which is, understood in kind of, in a dialectic struggle with the concept of political attachment, such as the concept of citizenship. And I found an interesting quote in the report of the 4 economists that, to me, actually clearly expressed this view. So the idea that the individuals owe some duty to the place where we live. So the idea to attach some duty to the individual based on actually the place where individual is located, where individual actually stay. Is that true in our world? Well, that's a change, I think. And so there is no longer, I would not say no longer, but at least the nexus has become, has lessened in its importance, I think, over the year, especially, after the, terrible experience that we have with the COVID-19 pandemic. So residents no longer function as a tax nexus. Why is that? Because we believe, and this is something that I put also in the title of the paper that I prepared for this conference, we live in the age of geodiversification. What does it mean? It means that every individual, every one of us, actually has vested interest in multiple countries. And I would say not just, various types of interests, like personal interest, our family, our attachment to friends, so on, so far. Economic interest, so maybe work interest, but also more broadly, with social interest in different countries. So we have different pointers that point potentially in multiple directions. And this render difficult to find a single place of attachment, so to speak, a nexus, like it was in the sedentary mindset, sedentary lifestyle, on which premises, in my view, the concept of tax resident is based. So, and this is somehow the, part I would like to be part of the debate. I think that residence has no longer become, a concept attached to the idea of economic allegiances, but actually has become a sort of elective allegiance. And here I took inspiration deliberately from a paper from Daniel Shaviro, published in 2011, where Daniel Shaviro argued about the rising electivity of corporate tax residence. And I do think that we have some similar issue. Of course, he was referring to the check-the-box rule, the famous US check-the-box rule, but I do think that we are seeing something quite similar. If you consider that most jurisdictions at the domestic level do not require physical presence. I mean, you don't have to look, very far away. The country where I am from, Italy, actually does not require you to be physically present therein. There are many tests, domestic tests, but not one of them mention physical residence. And it is not just Italy. Netherlands is the same. You just need to be registered somewhere, either in a register or at the municipality. In the case of the Netherlands, this does not mean that you are actually living there. And it might sound be, an academic exercise, but I think that due to the underlying force that I introduced this page, in particular digitalization, this is becoming, more and more true for a person living elsewhere, but become more connected to one country. Therefore, one person may decide just to check the box in one country because it's convenient to be resident there without actually spending any time therein. And this is also problematic, and here I would like to connect with something that I know will be discussed tomorrow about the new residence regime. Because if a person decides to move in that country, just, on paper, doing some paperwork, but without actually, living therein, and benefit also from a privileged status of residence, because another issue is that we have different categories of residence. So we don't longer have in many countries a single tax residence. We have, residents of category A and resident of category B, which, perhaps as, those nationals that are less fortunate, so to speak. So I think that actually we are experiencing a rising electivity of residence for individual. So that was my, let's say, past destruence of my speech. But what I would like to propose, well, to me, there is only one way to restore residence as a nexus, which should be applied both at the domestic tax level and at the tax treaty level, because we have two levels on which we should consider tax residence. And this is the idea of introduce a new PPT test, but it's not the principal purpose test, it's the physical present test. So it's the idea that we must introduce a threshold. I'm not saying necessarily 183 days, but at least some, requirements that in order to claim tax residence in a country, you must prove to physically stay therein for a certain amount of days per year. For instance, could be 90 days, and I will come why I say 90 days. Well, this concept of physical present test and accounting days test is already embodied by many countries, of course, so it is already part of domestic tax residence of many countries, but is also, and what I find particularly interesting, for instance, seems to be already part of international tax practice, because we do have a similar 90-day requirement for the common reporting standard, because financial institutions are advised to actually perform due diligence, in particular in consideration to countries that allow individuals to stay therein without requiring countries that give residence to individuals without requiring those individuals to stay therein for at least 90 days. So I do think that it's time perhaps to rethink the domestic tax concept of residence, and perhaps also to redraft our, the tiebreaker rule under Article 4, Paragraph 2, which it strikes to me that have survived quite untouched since the OECD model in 1963 was born. So with that, I thank you for your attention, and I'm looking forward to other presentation and to the panel debate. Thank you very much.
Thanks very much, Giorgio, for your presentation. I have comments, and of course also Mukesh has. I wonder whether it's more appropriate to have them after perhaps all presentations, so that we bundle them together with those of the commentators. So unless Mukesh differently indicates...
That's fine. I was suggesting the same thing. Let's not interrupt the flow.
Yeah. So let's move on to the second colleague, who is addressing the tax treaty problems related to individual, and that's the very host, Professor Svetislav Kostić. He's making a presentation on whether we should rethink the taxation of employment income under tax treaties. Svetislav, the floor is yours. It's now 4:28.
Thank you. So first of all, before the presentation is set up, I would like to thank, well, everyone present, and truly this has been a privilege and an honor to be able to host you, and I hope that the day, I think, went well, and I think I will not be able to spoil it with my presentation. I will be dealing with the taxation of employment income under tax treaties. Now, first of all, the way in which I will approach the issue is twofold. One is from let's say, an approach from a legal theoretician, and another one is more practical. So from a theoretical perspective, if you are a lawyer, you should be wanting to know the words that are in the statute. You should want to understand them clearly. And if you read Article 15 of the OECD or the UN Model Convention, there are some operative terms without whose understanding you cannot apply the rule. So what constitutes employment? Employment is a word which Article 15 uses. Who can be deemed as an employee? And who is an employer? So these three terms, if we don't answer them, we can't apply Article 15 of either of our, articles of our DTCs that follow Article 15 of either the OECD or the UN model. Now the problem is that if you read both of the models, you will see that neither of them provides us with a definition of these terms. And thus, Article 3 will tell us that recourse must be made to domestic law. But if you fail to define such relevant terms, this implies, common sense will tell you, that the authors of the documents actually thought that there is some principle global common understanding of this. And actually, legal theory confirms this. If you read Klaus Vogel, one of the immortals of international taxation, you will see that very conclusion, that there is a common international understanding of the terms employee, employment, employer, and that you can't really, even though reference should be made to domestic law, you can't do whatever you want or whatever it comes to mind, because these activities must fall under this understanding, this common international understanding. Now, when Klaus Vogel was writing this, perhaps he was correct. Perhaps there was a common international understanding of the concepts of employee, employment, employment relationship, or employer. But what happens, and this is what is happening right now, when domestic law is no longer certain as to what constitutes an employment relationship, who is an employee and who is an employer. And I will give you a very simple example. An Uber driver in the United Kingdom, and this is what the case law, it's interesting, you should read it. I very often like the humor of British judges. There is a saying in one of the verdicts that the idea of 25,000 independent transport service providers in the City of London is laughable. So quite clear approach by the judiciary. But in the UK and in the US, they have for a decade, their legal theory, not tax, but labor law legal theory, faced with the digitalization of the workplace, have argued actually for the introduction of a third category. So we live in a world which is based on a dichotomy. There are employees, and then there are independent service providers, entrepreneurs, sole traders, whatever you want to call them. What Anglo-Saxon labor law theory did, it said, well, we need to reflect the reality of the world that we live in, and we need to put in an intermediary category. One which is neither an employee but neither an independent service provider. And in the UK labor law, these people are called workers. That's the technical term that UK labor law legislation uses. And Uber drivers are not employees. What they wanted and what they got by winning every case before the UK judiciary is that to be treated as the intermediate category, as workers. Now, this is also something that has been prevalent in a number of jurisdictions. If you've read in the US, there was, from California emanated the so-called independence tests that actually tell you whether or not you'd fall within one or the other category. Many countries have followed suit. Serbia is one of them. In the EU, this topic is often referred as the problem of bogus self-employment. So what happens when we no longer can tell if a person is an employee? Now, labor law today is in flux. Not only is it having a problem defining who actually is an employee or who should be an employee, because labor law has a very inherent moral character to it, because it's been a result of 150 years of struggle for employee rights. But the problem is also that we have concepts now which are completely operable in a tax world of, for example, plural employers, wherein labor law will tell you, well, I don't care who is the exact employer within the multinational structure, as long as somebody is, that's sufficient for guaranteeing the rights of the employee. But who then assesses withholding tax? Because that's the mundane question that we live in the tax world. And the issue is, first of all, is this struggle that is to align yourself with the reality of a modern digital world and with the social issue of defending the 150 years of labor law struggle, is this a fight that the taxation, tax law should be a part of? And I argue that no. That we shouldn't be a part of this battle, and that actually we should go back to trying to assess our independent tax definitions of operative terms that we need to use in order to apply, for example, Article 15, maybe an approach of back to the future. You know, in the old times, it was not employment income, it was dependent personal services. So maybe trying to introduce new terminology, but in order to do this, what we first need to do is actually look at policy issues and rethink why in the first place did we decide to differently treat those who are dependent and those who are independent. When we rethink these reasons again, maybe we'll come to the conclusion that we don't need two rules, maybe we need just one. Especially if we combine this with the ability not only to be exceptionally mobile in a global world, but actually to be present in every market on the planet, especially in the service sector, by being completely static without ever leaving the premises of your bedroom from your laptop. Now, this is one part of what I'm trying to discuss. The other part is, sorry. Can somebody help me with the technology? Next slide. I am trying, but it's not working. The other thing that I'm trying to do is to look at the reality. Yeah, thank you. But it's stopped. Can you move it, please? So the reality of actually remote work. And the problem there, what we have is that, and I will give you an example to shorten time to explain. It's a Pakistani example. Just for funding, the Pakistani Tax Administration in 2020, the COVID year, audited 75,000 freelancers, remote workers who channeled $2.5 billion just using the Payoneer platform. We live in a world where a company can have headquarters in one jurisdiction, clients in a second one, or all over the world, and the workforce located throughout the globe without the need for that company to have any form of presence in the jurisdictions where the workforce is located, because you use platforms as employers. In such circumstances, the crucial issue which arises, and this is especially true, and Professor Browner has talked about it, many other people have mentioned this, especially in those developing country jurisdictions, where you have an educated workforce, but not a developed tax administration and infrastructure. In those situations, it is the collection of tax and perhaps even more importantly, mandatory social security contributions, which becomes a crucial issue for the jurisdiction in which the workforce is located, as the example of Pakistan proves. So, some proposals. In respect of the employment income article, actually more focus should be made on the exchange of information between the country of the employer, perhaps even the platform as the employer, and the countries where the workforce is located in order to ensure a timely and appropriate payment of tax. Also, modern technology now would enable us actually, if there is enough international cooperation, through the mechanism of assistance in the collection of taxes, to actually levy these taxes and mandatory social contributions at the level of the employer country, wherein calculations could be made and provided through the mechanism of exchanging information of the competent authorities. Also, this is something which I have proposed to introduce a new category, because this is something which, especially in the digital era, is quite relevant, and to introduce the concept of the work state PE, because the concept of having a workplace and a static workplace is completely obsolete, because, and I think the paragraphs of the OECD model relating to the home office are already obsolete completely, because it is the laptop that is the office. You can work in a park. I mean, look at the weather here. You don't have to sit anywhere. And is the laptop the place of work? So this is something that was what I decided to approach in my research. So looking at Article 15 first from the perspective, can I define the words that are in it and then apply it? And do I know what they mean? And then realizing that the concept of work as such, the way, the technological impact on the way in which we do work has completely changed, and perhaps threatened the ability to collect public levies of numerous countries, especially those that are the sources of freelance populations, and those are countries that domestically don't provide sufficient opportunities for their labor and talent. So thank you.
Thanks very much, Svetislav, for actually even saving time. So I can be positive about the fact that we can get back on schedule. You have raised also many interesting points, and I also have those comments that I would like to add, and I'm sure that I don't need to ask Mukesh, because he also would have some, but we have decided to keep the flow. Sorry, and for this reason, I would like to move on to the next speaker, which is Professor Tetłak from the University of Warsaw. Karolina will be presenting on a topic on which she's one of the greatest experts, not only in academia, but more in general, and that is taxation of artisan sportsmen or sportspersons. Now, Karolina, the floor is yours. It's 4:41. I see that you're wearing a very unusual color for your dress. Sorry for this personal comment, but it's we've been friends for quite some time, so I just want to make this whole moderation a bit less serious than it would otherwise be. Karolina, we're all looking forward to hearing from you. 4:41.
Thank you so much, Pasquale. I wouldn't be serious anyway, don't worry, you know me. And thank you so much for the nice introduction. So yes, I've been rethinking Article 17 for definitely more than a decade now. And at the moment, we have some very interesting developments as regards the article. So I would like to briefly discuss the direction in which we could be going with this provision, and actually why, and how we can learn from other provisions in the international tax world, and maybe what lessons we can learn from what we've had so far. So can I please ask for the presentation to be uploaded? Just a second. Okay. So anyway, the basic premise with Article 17, as most of, if not all of you know, is that we have the nexus of physical presence, but we don't rely on substantial presence in the source country. So unlike Article 7 and Article 15, for Article 17 applicable to entertainers and sportspersons, we don't actually need the presence to be so substantial. We need them to be physically present in the source country, though. Right. So in the article, there are several expressions that we've been thinking about and analyzing for years, and that are actually difficult to define and understand, such as the notions of entertainer and sportsperson, the concept of personal activities as such, and the concept of activities being exercised in the state, and so on. So these have all been controversial issues and issues that we've discussed for years. However, recently we have some emerging phenomena. So Dick has already discussed the problems with influencers, the concept of influencers, and let me focus on e-sport for a moment. This is an emerging phenomenon, and this notion basically refers to video games. Unlike traditional sports, e-sports are just computer games, and I guess the people who do that feel better about themselves if they call themselves e-sports persons. But under tax treaties, it means that we actually have to treat them as sports persons, especially with that in many countries under domestic law. Virtual sports and intellectual sports have already been defined as sports disciplines. So under double tax treaties, we have to take it into account, especially that the market is growing, and in the coming years, it will indeed grow exponentially. At least this is what we see after the COVID pandemic. We also have other interesting developments. We've already talked about influencers, but in terms of Instagram, there's been a lot of banning of content involved. And as Dick already said, the influencers can basically post whatever they want. If they don't have a forum where they can do that, they just move somewhere else. And there are social media websites where they can do that, and they earn huge money for posting indeed whatever the audience requires. As Professor Rosenblum already said, this is actually not a tax question. I mean, are they sportsmen? Is that an entertainer? How can we define and interpret such a notion if it's actually not a legally defined concept? Both tax advisors and tax administration have to go into detail of the extent to which it's actually entertaining. And let me give you another example of a very interesting phenomenon that we can see developing, especially now during and after the pandemic, the so-called edutainment. So it's kind of a mix between education and entertainment, or entertainment with an element of education. And in such combined cases, it's really difficult to establish whether it's educational. So because if it's teaching, then we have a separate article under double tax treaties that applies to teachers and professors and researchers. And if it's entertainment, then of course this would fall under Article 17. It would be interesting to ask if we should actually apply the principal or primary purpose test to such mixed cases. As regards the example of OnlyFans, the website with mostly erotic content, or the esports events, one of the main problems is basically the place where the activities are exercised. Let me give you an example of one of the biggest world championships in gaming, which is the League of Legends. We, of course, have other huge esports events like this, but this one happens in 4 different cities in terms of organizers. So we have to differentiate this entity, like the entities of the organizers, and also players who are located worldwide and they are streaming from anywhere in the world, and viewers who are also located worldwide and they are paying, subscribing for the content. How can you answer the question where it is located? Actually, extremely interesting lessons can be learned from VAT provisions and VAT cases. One of the most interesting case I've heard about, and thanks to my dear colleague Giorgio Beretta, who introduced this case to me, it was a Dutch case that involved a Dutch supplier of services involving basically live erotic webcam sessions that were broadcast live to viewers all over the world, possibly, but in this particular case, the viewers were based in the Netherlands, and the models, the dancers, call them whatever, they were based in the Philippines. And under VAT, we have a similar problem and a similar question that we ask under double tax treaties, because there's also the concept of entertainment services, and they need to establish the place of supply of such services. And the wording in the VAT directive refers to the place where the activities are physically exercised. And of course, the court had to answer the question. The court also was asked whether these were entertainment services or actually digital services, but focused on the entertainment element, and basically decided that the activities were physically carried out in the place where the service provider, the organizer, was established. The idea behind it was very practical. Basically, the court wanted to make a reasonable solution. But it's interesting that in this case, they noticed that what we are used to, which is a very coherent unity of action, time, and place, is actually broken in the case of such services. So basically, this means that we need a new nexus for entertainment services. And by the way, in the VAT directive, there's been a change, and there's new wording used, which refers to the activities actually taking place rather than being physically exercised, which is of course a very subtle difference, but we lawyers can do a lot with such different wording. So let's have a look at that. Under VAT, we speak about physically carried out services, activities actually taking place, and under double tax treaties, under Article 17, the place where activities are exercised. this all means something else. And in this context, we should actually think about what we wanted to target under Article 17. In the last session, we already tried to discuss this, this interesting topic. Was it about mobility? It seems not, because we have other extremely mobile services, including those around sportsmen and entertainers, and these people are not covered by Article 17. So in this case, Article 17 is definitely under-inclusive, in the sense that its scope is too narrow, because it doesn't cover people who are able to provide their services in many countries in the world, and they don't establish substantial presence within the meaning of Article 7 and 15. Did we try to cover high net worth individuals, high earners? Well, when we look at the practice, then probably not, because in the world of sport, where the big money is really involved, which is the sports mega events, such as UEFA, Championship, World Cup, the Olympic Games, Article 17 actually doesn't apply. The interesting thing is that it doesn't apply because of the negotiation power of the sports bodies behind these sports events, but that's the fact. The source countries that fight so much for including Article 17 in their treaties, when they become host countries for sports mega events, they forget about Article 17 and the source country right to tax. So I guess it was not about that. Definitely Article 17 is over-inclusive in the sense that the scope of this article is too broad, and it covers individuals who are not fairly treated in comparison to those who are in a similar situation. So at the moment, we need to ask ourselves if we actually want to cover remote services maybe with this article also, and what lessons we can take from the international tax environment. So Dick Molenaar has already made a proposal under one of his in one of his papers regarding lessons that can be taken from Pillar 1 and Pillar 2. And for many years, we've been discussing it academically, that Article 17 should maybe be narrowed in the sense that we should use the proposals, the optional versions suggested in the OECD commentary, such as to apply the de minimis rule, the minimum threshold above which sportsmen and entertainers should be taxed, to leave out those who earn just a little money, to limit Article 17, paragraph 2 to abusive scenarios, and to allow basically for easier filing of tax returns. As I've already discussed, we could take some lessons from VAT, and also we should maybe think if we can make it more coherent, like we organize separate conferences for double tax treaties, for VAT, and sometimes we don't think about the fact that there are these are the same services, but we use different concepts, we use different criteria under VAT and under income tax. So maybe this is something that could also be kind of synchronized. And in terms of the online world, let me ask a question. Maybe we should introduce a new separate article that would apply for services differentiated based on a new criteria, Like, when we look at Article 17, the mess with this article results from the fact that the reason why we have this separate article is different than the Articles 7 and 15. These articles are based on legal criteria. So it's employment or business activity. Article 17 is differentiated based on the nature of the services. So it's a completely different criteria, and hence the overlap. And maybe we could think about some new nexus, like something that would be a new up-to-date criteria for differentiating and carving out individuals, like maybe those who can be mobile, those who can provide online services, something that really stands out, not because it's entertaining or it's sports, but something that in the new world of provision of services could be indeed differentiated. Okay, so to pretend that it's easy, I prepared a 5-step action plan. Like, this is something influencers do. They give you these 5 steps how you can make your life easy and beautiful. So I did the same, and the first step would be to discuss what the article already applies to, what problems we have with it. Then rethink it. This is what we are doing. What is actually the condition of the taxing right of the source country? Should we actually tax it in the source country? We can see that under Pillar 1, Article 17 is the most similar one, actually, so it's not that easy to kick it out right now, as many suggest, because it seems that this article is kind of in line with the new proposals. Then, as I said, we should think who we actually want to target. If Article 17 is both over-inclusive and under-inclusive, maybe we can differentiate a new group based on new criteria, something that would be more up to today's world. What income we want to tax, and as I said, basically where. Should it be the country where they are present, where the viewers are present, where the event takes place? If it takes place online, then where is it? And so on and so on. And then maybe changed that paradigm. What I mean by stopping sectoral thinking is that when you look at income tax in general nowadays, we can see that there are actually multiple small income taxes emerging. Even the recent European Commission proposal to tax or to add an additional income tax on energy companies, and it is an example of a sectoral tax. So it seems that we don't have a new idea for fixing income tax. We are just kind of checking where there are leaks, who's abusing the existing rules, and just reacting instead of coming up with a new idea and really making it up to date with today's world. Okay, thank you very much for your attention, and I'll be happy to discuss it.
Dziękuję, Karolina. So it's now time to move to the following presentation. This is going to be a joint presentation, if I understand correctly. And I assume or understand that both colleagues from Slovenia are physically present in Belgrade. The focus of their presentation is how should we deal with various social security challenges in the digital age and the era of migration. So I hand over to our colleagues from Slovenia, GregaStrban and Luka Mišič from the University of Ljubljana, or one of them.
Yes, thank you, Professor Pistone. I think it's the wrong presentation. If you can change it to the newer one, we would be grateful. Thank you also to Professor Kostić for recognizing the importance also of social security coordination and inviting us to this conference. First, a disclosure, we are not tax lawyers, as you may know, and you will see in our presentation, so go easy on us. And we'll go easy on you on social security coordination. So I'm also Vice President of the European Institute of Social Security, Vice President of the International Society of Labour and Social Security Law, and most importantly, coordinator of a MOVES project, which is European Commission, European Union Finance project on free movement of workers and social security coordination. And it has been recognized the importance of the topic of social security coordination law and tax law and their interaction already in 2014, and a report has been published. An update of that report was written last year, and it will be published this year. So there is a recognition also by the European Commission that these are two important fields of law. Now, I will not dwell long on the concept of social security, as it is the competence of member states. It is a substantive part of social security. And you have different factors in every country, so social security systems can be quite different. And we usually discuss taxes and social security contribution in the same sentence because there are some similarities. They're both coercive. They're usually collected by the same authority. It could be tax authority in many countries. There is a tendency to avoid paying taxes and social security contributions, so there's quite some similarities. But there are also quite some distinctions because social security contributions have a specific purpose. They should be intended to finance social security, whereas taxes may be more from a general nature. And then we have socially earmarked taxes. So it's always a question of a definition. What is social security contribution and what is tax? Because you can have easily different countries responsible for collecting social security contributions and taxes. If you just imagine, it was already mentioned today, posting 183 days in tax or under tax treaties, but you have 2 years under social security coordination law. So after 6 months, you have to pay taxes in another country, but contributions you can still pay in your country. And now imagine if you have to pay taxes in Denmark, where also social security is financed out of taxes and taxes are high, and you have to pay social security contributions in Germany, where it's typically social insurance when contributions are high, then you might end up paying a lot. And it could also be vice versa, of course. And there have been some cases by the Court of Justice of the European Union law. You will remember CRDS case or CSG case from France, or some other cases where Künstler Sozialabgabe, I think it was another case, but where the court says it's tax, it's not social security contribution, but for the others it's social security contribution. I don't know if socially earmarked taxes make sense to you. I think it's the word we came up with in 2014, but if it's already recognized, that I'm very happy. We didn't know that it existed before, so at least that. The role of European Union and international law. In the European Union, we have coordination of social security, law, which means we have a regulation 83/2004, which has links all social security systems together with one unifying measure. It's a bit of a paradox of regulation because it's a unifying measure, but what is unified is not the substance of social security, but only the formal part linking different social security schemes. And we have no uniform, at least, coordination of taxes because it all stays within the double taxation avoidance agreements, and that might have some different outcomes. We also have bilateral and multilateral social security agreements, which can be within the European Union, like in the Nordic states, or we could also have them outside of the European Union, linked to European Union, if I'm a bit European-centric, like Convenio Multilateral de la Seguridad Social Iberoamericana, for instance, and some others. And of course, social security next to taxation is key for free movement, especially for people, because if you move to another country, you would like to know where you will have healthcare. Will your pension be covered? Will you be entitled to family benefits, and so on? It could be a big factor next to pay and taxes to move or not to move, basically. Now we have different principles of social security coordination. I will just briefly mention them, and my colleague Luka will then deal with some specific issues. The first one is equal treatment in the country where you are. So it's based on European Union citizenship, and also third country nationals should be treated equally when moving within European Union, at least if they're moving between two member states of the European Union and are legally in the European Union. Then we have a rule which is sometimes quite controversial and most difficult one to establish: which country is responsible for your social security. So single applicable legislation. The main rule is lex loci laboris, so where you work. But the problem is, as already mentioned, what is work? Not only what is work, but who defines what work is. And it is defined by each of the member states, and different member states may have different definitions. In some you may be a worker, in some you may be self-employed person, in some you may be economically dependent worker, which is not a worker but self-employed person, so a third category, and so on. But if you work simultaneously in two countries, then the 25% rule may be applicable, as you already mentioned this morning, which changes the competent member state. So if you're working in two countries, residing in one, and at least 25% of work is that country, then lex loci domicilii rule would apply. But don't get me started what is residence in Social Security coordination law, because that is a very specific issue, and we could discuss it later on residence. Because we had a case, I versus Health Service Executive, for instance, where an Irish person was living in Germany for more than 10 years, and he did not establish residence there. Because for residence, you need not only corpus manendi, but also animus manendi. And he was in a hospital. He always wanted to return to Ireland. He wanted to pay taxes in Ireland, although he was not liable to pay taxes. And the court says, yes, he did not establish residence. So that's a specific issue. Then teleworking. Is it posting? Is it reverse posting? Can your employer send you to another country where you're working and teleworking for the same employer? That would be kind of reverse posting. We have special agreements during COVID crisis, like Luxembourg concluded based on Article 16 of the regulation, which is flexibility clause, bilateral agreements with countries, just disregarding the regulation on applicable legislation, saying that even if you work in another country and it's still very physical presence of work, like in Partena case, then it is not the lex loci laboris rule that will apply, but where your employer is based, just for convenience purposes, that countries can do that and make separate arrangements. And then a specific issue of workation. Are we in Belgrade working? Are we on vacation? Are we combining both? If we are not working, then we are on vacation. Where is our place of work? If we are working, then that opens the different issues. And A1 form, usually on the conferences within European Union, professors ask, or I usually ask the provocative question, do you have A1 form? A1 form is confirming that you are socially insured in the country from which you're coming from. And do we need one? Do we provide services? I don't know. We are not paid from this conference, at least, or that many conferences we are not paid. But if it would be service in the internal market. We would be working. Our employer would be sending us, so we would have to have A1 form and so on. Then it's protection of rights in course of acquisition, so aggregation or totalization of all periods, and protection of acquired rights with export of benefits, with specific rules on healthcare. We have special rules on cross-border healthcare within the regulation, but also special directive 2011-24 on cross-border healthcare or patients' rights at cross-border healthcare. And there are some specific rules on unemployment, but Luka will deal with that. Good administrative cooperation, which is the last principle, and I will stop here. We have two big projects. One is ESI. One of my students says, oh, Messi. I said, no, Messi, ESI. Or NESI, no NESI, ESI, okay. It's electronic exchange of social security information. So it's linkage of all social security institutions that portable documents can be exchanged between them. It should be applicable 2 years after the regulation came into force. It came into force 2010, so 2012, it should be already fully operational. It's not yet fully operational, so I think this year it should be. And the first documents, electronic documents, were exchanged between Slovenia and Austria in 2019. And the second one, which is even more interesting, is ESPAS. It's a follow-up of the previous project of European Social Security number, and ESPAS means European Social Security passport in a way. So we have seen that during COVID, almost everything was possible. Unemployment insurance for self-employed, no reviews, peer reviews of articles on COVID-19, electronic, certificates of vaccination, of whatever, everything was possible. With ESPAS, it could be the same. I mean, the technology is there. Why would you have plastic, not even smart European health insurance card? Or why would you need a paper of A1 form? Why couldn't you have it on your phone? And to be honest, in some conference, we established that your phone is basically your lover, because the thing you go to bed with and you wake up with the morning with is your lover. If that's the definition, then a phone or your laptop is your lover. So ESPAS is the next project, and it would be really interesting to link both of them. So social security institutions and individuals with ESPAS, and then we would be really moving freely within Europe. And by the way, European health insurance card could also be used in Serbia, at least for Slovenians, based on bilateral social security treaty. I stop here and give the floor to Luka. Thank you.
All right, thank you very much. I'll be brief. Yeah, hope so. Now imagine you've been employed for years and years, right? Sitting in your office and then someone comes knocking at your door and knock, knock. Who's there? Robot. Robot who? Robot that's gonna take your job who? And suddenly you become unemployed, right? Um, of course, what you can do in the EU is seek employment elsewhere outside of the competent member state so that the demand of and supply of labor meets in the common market most effectively. But why is the exportability of unemployment benefits limited? Let's think of pensions, for example. You retire in Germany, you move to the south of Italy. Of course, your pension rights are exported regardless of the duration of your stay there, because you have earned your sort of your social right to a pension. When it comes to unemployment benefits, of course, the competent member states of last employment, where you've been employed and then you've lost employment, they don't want to finance you seeking employment elsewhere in other member states, right? They don't want to finance benefits for your integration into the other member states' labor market. So exportability is limited for either 3 months or 6 months. Usually before going to elsewhere to seek employment, you first have to be integrated in the labor market of the competent member state where you've lost your employment for 4 weeks, meaning you first have to seek employment there. Of course, imagine being a, I don't know, a highly skilled individual, a doctor or something. Of course, the member state would want to sort of keep you there and not allow you to leave and seek employment there on account of this unemployment benefits that are paid by that member state. All right, Grega has already mentioned posted workers, right? The typical, the traditional example would be the Polish plumber posted to the UK. Now that the UK is out of the picture, they have to be posted somewhere else, for example, Germany, right? And Poland or Slovenia, if you're posted from Slovenia to Austria, remains, so Poland or Slovenia would remain the competent member states in the field of social security, meaning social security contributions would be paid there. If the posting does not exceed the duration of 2 years, if one posted member is not posted to substitute for another posted worker, with exceptions, limitations to intra-group postings, meaning postings within the same business or undertaking. And of course, posted workers first have to be integrated into the labor market of the member state where they're posted from, in order to prevent sort of the intake of labor from elsewhere and just posting them to other member states, right? Of course, questions of posting, issues of posting bring up the sort of the tale of the mythical beast, if I may, from the east or from the south, looting the riches of the west and of the northern member states. And both the coordination of unemployment benefits and posting are the two hot topics, I think, in the field of social security, because they relate to social dumping, and in the field of labor law as well. And moving on to frontier workers, they have been discussed in the morning. I think cross-border workers, a subcategory of cross-border workers, are frontier workers. Those are workers residing in one member state, working in another, and returning to that member state of residence at least once a week, but commonly on a daily basis. So my typical example would be I don't know, friends of mine living in Maribor, Slovenia, working in Austria, for instance, in Graz. That's like 30 minutes away, and going back usually every day. So what if a frontier worker becomes fully unemployed? He has lost his employment, for instance, in Austria. That was the member state of last employment. According to the Lex Loci Laboris, that would have been the competent member state. But special rules apply to frontier workers, and suddenly the member state of residence, that would be Slovenia in my case, becomes the competent member state. Now, why is that so? The sort of the political, how should I put it? The politically correct explanation for that phenomena, or that rule that is a phenomena, is the following. Frontier workers are more likely to regain employment or full employment in the member state of residence because they speak the language, they know in the environment, etc. Nonsense. Think of frontier workers who have worked in neighboring member states throughout their whole lifespan, throughout their careers, right? They might even not know the professional language of the member state of their residence, but are fluent professional speakers in the other member state, etc., right? So rules would, of course, have to change, but they're at a standstill because there's a complex mechanism of reimbursements in place between the member states from which, as a rule, the wealthier member states benefit. But unfortunately, I do not have enough time to go into that, nor will I go into simultaneous activities because they've been mentioned, I think, in the morning, and you mentioned those rules. And I will speak only briefly on remote work. There's talk of changing the regulation 883/2004 in the coordination of Social Security systems, or it's implementing regulation 987/2009, where the applicable legislation would shift from one member state to another if a person would be performing work remotely from another member state. Okay, let me give you an example. You're employed in Austria. So Austria is the competent member state according to the Lex Loci Laboris principle, but you work remotely, right? Not, let's say, from Slovenia. The idea is of introducing a threshold similar to the simultaneous activity threshold that, for example, after 25% of your employment actually being carried out, exercised in other member state, in the member state of employment, then the competence would shift, for example, from Germany to Slovenia, or from Austria to Slovakia, or from Austria to the Czech Republic. And why am I mentioning those examples? Of course, because the employers from high-income member states could have an incentive of making remote work or at-home work mandatory for, let's say, 1/4 of the time, so that the competence would shift and that Social Security, well, they would have to pay, as a rule, lower Social Security benefits than the member states of employment. And that is sort of a change that we have to think about in order to prevent what would be that sort of reverse social dumping or dumping in favor of the employers from high-income member states. I will end here because I just wanted to sort of show a few peculiarities in the Social Security system, Social Security coordination system. There are a lot more, but I don't have the time to speak about. And yeah, let's leave it there. And thank you very much for your attention.
For this presentation, I have a lot of sympathy for the problem of those persons who are mobile across the European Union and are forced to face a number of problems with Social Security because of their interest to work in more than one country. And I'm sure that some people in the room might understand whom I'm referring. Now, let's move on to the moment of the so-called panel discussion. And we have two colleagues who have this task. Marco Felder is the first one. Marco, the floor is yours.
Thank you, Pasquale. Yeah, let me summarize the discussion and maybe bring in some additional thoughts. We talk about increased cross-border mobility, and the people that do know me, I was heading a tax authority in my former professional life, and we talked obviously a lot about taxes, but at least a few times a year we also talked to social securities. That means there was an interaction, a frequent interaction. There were common guidance letters, yeah, and let's say clarifications. This is my first panel, yeah, where we have social security experts. And I think that happened before. Pasquale, you mentioned that, but probably that was rarely the case, especially in a cross-border context. So I believe that's something that we will see more often, yeah, in the future, and something I believe is very necessary. So we heard that taxes and social security they have a lot in common. Yeah, first of all, every state, yeah, has a unilateral legislation, be it in tax or social security law, and every state, yeah, has bilateral agreements to coordinate the systems, while the bilateral treaties, okay, they have a lot of parallels, but at the very end of the day, ultimately, there are also a lot of difference in it, yeah, because they always address also specific issues. And also taxes and social security have in common that there are multilateral agreements in place. Yeah, Grega, I think I read in your contribution that the treaties, yeah, and the social security system go back basically 500 years, yeah, to the 17th century. And also tax treaties, yeah, are very old, yeah, so that is a common denominator. And there's another common denominator, and we heard about it. So every jurisdiction will probably protect its own interests. Yeah, nobody wants to see exports of social benefits. Yeah, without any necessity, and the very same is true for taxation. Yeah, so nobody exports taxes. Yeah, just like that. But there are also a lot of, let's say, contradictory issues. So what does a tax system serve for? Yeah? Basically, we generate income to accomplish general tasks. We have to pay the administration, yeah, we have to pay politicians, we have to pay courts, we have to pay hospitals, yeah, streets, public infrastructure. So the purpose of social security is a different one, yeah, by nature. Basically, it serves as income. It provides income replacement benefits, yeah, caused by old age, accidents, health issues, all that. So the purposes are different. So what I want to say, those are very developed systems, yeah, that grew over centuries, yeah, and they are very dynamic concepts, but at the very same time, they have a very static aim, and it is a very difficult task, but a very important task at the same time, yeah, to match the systems better in the future to solve the problems that we have seen recently. Then, also from my own practical experience as a tax lawyer, I want to give you an example. I was re-domiciling, yeah, an attorney from Germany to Liechtenstein. That was not tax-driven, by the way, but I realized, because there was still a permanent establishment in Germany and all the income has been taxed there. But what we realized is, never shift the domicile of an individual from one country to another, yeah, without scrutinizing the implications in social security, because the implications can be huge. In that particular case, yeah, if that would have overseen, yeah, it could also result in liability issues, because the social security contribution was much higher, for example, in Liechtenstein compared to Germany, and those can be very, very big amounts over the years. And then, something that we also highlighted today is increased mobility does not affect the different, let's say, people, or people are affected differently. So what I want to say, we talked about commuters, yeah, that cross the border every day. So that's probably feasible, but with telework, yeah, so there definitely we have issues to resolve. We second people, yeah, to other countries for a few months or even years. But a high net worth individual, let's take, for example, a German resident, yeah, that owns shares in a very big company, yeah, probably, yeah, he's not dealing with social security contributions, but rather with exit taxation, yeah. And I'm wondering myself, yeah, how countries every year, yeah, make exit more difficult for individuals, especially affluent people. And I asking myself whether that is really still in line with European principles after all. So I'm wondering about what we will see there, yeah, in a few years from now. It has become very difficult, yeah, for those people to move from one country to another. Before I pass over the word to the second commentator, Ignacio, there's a lot of work ahead. And we heard the discussion earlier today. I mean, pillar 1, pillar 2. So maybe we exaggerated sometimes a little bit, yeah. It would be my wish, yeah, if I may say that we do not lose the great picture, yeah. Not everything necessarily needs to be or become more complicated. Hopefully, yeah, we will find effective and simple solution also. So that would be a wish that I would like to address. So I hand on the word to you, Ignacio.
Thank you. I would like to thank the opportunity to be here and to be invited to attend this conference. I'm a tax advisor. I work as a practitioner, so I'm not so familiarized with the academic environment. So I thanks again. Thank you for your papers and thank you for your presentations to all the authors. As I'm the last of the day, I will try to be very brief. As you know, I came from Spain. So I will try to bring back some example of the day to make some comments to the authors, just to know his thoughts. Based on the presentation, I would like to separate the two presentations relating to personal income tax, or the presentation of Karolina and Giorgio, and the presentation of Luka, Grega, and Svetislav. And I had the opportunity to read the paper of Giorgio. Sorry, and I have also the opportunity to discuss with him today his paper, because I have I'm a tax advisor, and here in Spain we our country is very special. So bringing back an example that we have commented today, we have an example of a YouTuber, for example, that moved from Spain to Andorra because, as in Spain he was taxed on a worldwide basis, he paid a huge amount of taxes. He moved to a country called Andorra, that is a small country with a low tax rate, or probably no tax, but it's not a tax haven. It is a treaty country. Okay. So when Giorgio mentioned, and we were discussing in the morning, that there are some countries that his advice, I agree with his advice, that some countries would need to have a connection between the presence of the individual in the country, because there are some countries that they would be considered tax resident in the country with no presence. We would always try to advise the client, okay, if you move to a country, although it would be a treaty country, you would be able to get a tax resident certificate according to the country. Every day is in the press that the Spanish tax authorities would challenge that you are a tax resident in such country. So our advice is always that you have to be prepared and you have to work in a pre-defense file. Okay. So my comment, I'm sorry because it's been too long, for Giorgio and also for Karolina, is in an example of a YouTuber that is taxed on his worldwide income, and we are not sure if he's an entertainer or not, but it's also probably selling products. What would be your thoughts about this case?
So we have some specific questions, and unless Mukesh differ indicates, I think it would make sense to start by asking the colleagues who have made presentations to answer those questions, and then I have some comment, speaker per speaker, and I'm quite sure that Mukesh also has comment speaker per speaker. So we will then address them in that order. So Mukesh and I will make comments or questions speaker per speaker, but perhaps we should start by having the colleagues answering Ignacio's questions.
Yeah, thank you, Professor Pistone. I will start answering the question to Ignacio.
Well, I think that my point in the presentation was just that we can no longer, put the equation between living in that countries and necessary, and like making the equation of be a tax residence in a countries and at the same time living in that country. This is because of digitalization. So the possibility to actually, yes, move at the, as you mentioned, create an appearance of residence. So moving to a countries, of course, we do that if tax-wise, tax convenient, move to that country, perhaps fulfill the condition for being residents therein. But if these countries does not require you to be physical present as Spain does, because as a physical present test, you can just register, check the box, and then you can manage somehow to do your, affair in that countries from a remote basis, basically, using digital tools. So that was my point. There is no longer, it's easier to lessen your connection with your resident states, and therefore you can no longer predicate the fact that there is a tax nexus by simply assuming residence therein, which means that the concept itself of residence became meaningless, or if you want, electivity. Elective, as I put in the presentation. And this is particularly worrying if by actually you are not just acquiring residence, but you are acquiring a new type of residence, a special type of residence, like with the many, new regime for new residents that we have all across many countries in Europe. In Italy, we have actually 4 regime for new residents, for different type of new residents. So you create different categories, which actually also are, in my view, in breach of the principle of equality, of treating everyone the same. And also we heard this morning, I don't remember who mentioned that about of reporting. So basically, do admit. Yeah, I will finish now. No, I just want to add about the administrative side. So the fact of reporting, because one of the benefits for new residents, for instance, is that you are able not to disclose your foreign income. So also this is, part of the benefit that you can gain.
So I will just add, yes, I will just add, if I understood your question correctly, what you would advise to someone who's a YouTuber and does what YouTubers do and also sells some merchandise. So as long as you establish the residence, you already know the residence country, then the whole analysis under Article 17 would start, and you would have to establish to what extent his income is derived from entertainment activities, which is of course a lot of getting into what he's doing and analyzing the scope of the income. And then basically all income that is outside of the scope of Article 17 would be taxable under Article 7. So that would be regular business income from the sale. Just a very short comment regarding esports. In esports, it's actually very funny because when you think about the types of games, I guess you know that there's a lot of shooting, driving cars, but there's also a lot of kind of avatar development. So like they create a virtual person. And we actually had a very funny case in Poland where there was an international e-gamer who was creating a kind of a knight in shining armor, a knight in shining armor. And he was developing armor. And we have a special rule for business income for craftsmen. And he basically applied for special, very low tax rate for crafts in, armors and swords and shields and stuff. And he actually won the case. And the tax administration agreed that he was a craftsman doing that.
Thank you very much. This also shows why it's really important to discuss theoretical issues and practical implications together. I'm not sure, Mukesh, what do you think if we first see if there are hands raised in the room? Because I immediately, so we first have to see if...
Yeah, there are quite a few. So why don't we...
Familiar to me from the back. One is there and the other here. Each other. Few more hands, but I'm very familiar. I can recognize the two gentlemen from the back. So they know who I'm talking about. And are there more hands, Mukesh? Because you are in a better position to see who raised her or his hand first.
Yeah, I can see Patricia as well. We'll count you.
Don't we need
Patricia? Who was first? Patricia? Must be Patricia Brown.
Yeah.
Hi, Patricia.
Hi, Pasquale. How are you? So I could have questions for everybody, but I have one question that has been bothering me since I started writing the manual on 12B. And that is because I have a teenage daughter who, I think all the influencer examples you gave, the influencer is getting paid by a fashion house or YouTube. But of course, my credit card bill shows payments to Patreon and Twitch. And the question is, does 12, I don't have to worry about it because the US doesn't have 12B in any treaties right now. But if it did, would 12B potentially apply to those sorts of payments?
Yeah, I would say definitely. Definitely, yes.
Yes, Polish courts.
That was clear.
Would you like to
Dick,
support?
do you believe what? What? They're not it. So they're not income?
The tax treatment or difficult to vary from country to country.
Okay, I have a couple of questions. One is for Giorgio. The question is the following. I just understood that your position on allegiances that is need to move forward and therefore to consider that it would be better to have a physical presence test, a PPT, which is not the usual PPT, for residents, both for domestic and treaty purposes. Now, I understand for treaty purposes, I think it is a sort of approach that also the Commission followed with regard to shell entities for a personal connection in the proposal. For domestic, I would say there is no reason unless you want to narrow down the scope for the application of certain selective regimes that you were mentioning before. Now, the question for you would be, do you think that this might have an impact on the proposal Peter Hongler put forward this morning in the sense that having this type of connection with his physical presence makes less harmful or not harmful if we look at BEP Section 5 by analogy, this type of regimes? And the other is for Svetik and Karolina as well. Svetik correctly pointed out that there is no definition of employer-employee employment. And I said before to Ana Paula, thanks God there is no definition. Because generally you have problems because of categorization of income, and it's because either the commentary is not clear, or because when you see some words and you think that there is a common meaning, there is no common meaning because everybody is looking from his own culture, that term or similar term. And why Karolina? Because she's a main expert of green and the main expert also of artists and sportsmen. And now the question is, what is bad with Article 17? Article 17 is, in my opinion, I'm not an expert, very badly shaped article, bad result. First of all, because it doesn't use a term that is used under domestic law generally for categorization for tax purposes, which creates a problem. And then use terms that you need to, I know, Pasquale, you're blocking me. And then you need to find a solution. And Professor Rosenblum pointed out, and you pointed out, that is a problem on not being clear to the purpose. So would you think that it would be better to replace Article 17 with a different article that makes clearer what the kind of income or the situation, not the person, the situation that you want to tax? At least you have a sort of based on purpose question. Yes, Pasquale, finished. I pass to Mario.
Yeah. Do not know whether Professor Kostić.
But I have
7 p.m.
I have a 30 seconds remark. No, looking at the title of the conference, which is International Tax Challenges Raised by Mobility of Individuals' Workforce as a Result of Digitalization, the question that comes to my mind is whether the examples that you took on your slides, so OnlyFans and esports in particular, whether they are really examples of mobility as a result of digitalization. Because based on my experience, I might have a limited experience, I don't know, but based on my experience, e-gamers, they're not mobile at all. They sit in Andorra and they play remotely from home. And do the same in Dubai, or where there is no personal income tax. So there is, I think, something that we are missing here, the mobility. Certainly we have something which is a creature of the digitalization development.
Thank you for your 30 seconds question. You're not Italian, you are. Answers?
Yeah, actually, the questions were so long that I forgot what the point was. Yeah, but your remark was brilliant. No, it's okay. I will.
So the questions, and I think it's important to use the time efficiently.
Yeah, I will just say that true that we discuss actually mobility in the context of virtual reality, which doesn't involve mobility. It just involves being everywhere. Being everywhere, it's not the same as being mobile. So when I said that we maybe need to change the nexus, maybe we need to change the paradigm, I also actually meant that we have old criteria based on what's been said, a very sedentary lifestyle. Actually, e-sportsmen have an extremely sedentary lifestyle. They hardly move to the kitchen and back. Yeah, well, maybe we should come up with a new article responding to your question, Paula, as well, that would be able to address the new context of mobility, which is, as I said, being everywhere rather than moving around.
More answers?
Yeah, I will try to be very brief. I mean, I think that the case that Mario mentioned about, I mean, the case of eSport was about what I referred before as virtual, immigration. So the ability to be connected, as Caterina said, with the world, at the same time. And instead coming to the question of Paolo, thank you for your remark. And I don't know whether, introducing a PPT test, a physical presence test, will make tax regime, residence scheme, let's say, less harmful. What I just point out is that they will restore some sort of meaningful nexus between, a country, be a resident of a country, and actually, being there. Because ultimately, I mean, the concept of residence, I think, from historical reason, it presupposes a connection between, an individual and a territory. That is also in the commentary on Article 4 in the Klaus Vogel, and this is for this position also of Ismer, which is commenting on that. And a brief remark instead regarding the application of those residence criteria for tiebreaker rules. I do think that here I do see two problems with the current tiebreaker rule. One problem is, I would say, quite obvious, is a problem of interpretation. They use open worded concept, like, the concept of a viable home. What is a viable? There was a famous, as you for sure remember, a decision of the Italian Supreme Court Italian Supreme Court that in November 2017 decided that basically a Russian citizen as an home viable at is lower in Italy without having this partnership be registered anywhere. But so one problem of interpretation, but I think that more theoretically, but at the same time more fundamentally, we have a problem in the sense that we try to define residence, particularly if you think about the concept of central vital interest, by referring to assets, so basically to the source of asset, which however are becoming more and more digitalized, which means that we are unsure about the source of this asset, which create a kind of circular problem in which residents refer to source, but source is uncertain, and sometimes residence is used a criteria to refer to source. So it's a kind of circular problem I see here. So that was my remarks.
Would like to hand over to Mukesh and ask Professor Kostić if we can continue until 6 p.m. Central European Summer Time.
You are the master of the program. You have my blessing for whatever.
Thank you very much.
Pasquale, it's 5:49. So what I wanted to do was quickly comment on some of the research that was presented. My job is easy and difficult. Easy because there's very little time. Difficult because if you have to add on to all the seminal work, research work that experts have done, it's always a challenging task. Let me first come to the concept of tax residence. I agree with you that the concept of physical presence has become an overarching objective of the domestic law and the treaty law. However, if you go back into the history of determination of tax residence, all the adjectives that we use, dwelling house, abode, economic allegiance, so on and so forth, they found mention of these terms in many of the treaties. Over a period of time, treaties have got simplified, domestic law has not got simplified. So if you look at just the common law countries on how these terms have been interpreted by the courts, you'll be surprised to know that there is a degree of coherence that ought to have been achieved between the domestic law and the treaty definition that has not been achieved. And I'd like that the future of determination of tax residence addresses these concepts in the domestic law. Otherwise, we have the acts of Article 3, Sub-Article 2, domestic law definition, unless the context otherwise applies, coming into play in many, many countries. I also want to mention two things. One is the general principle, which is evolving now. So there is a principal purpose test for businesses. I see the future of principal purpose tests being applicable to individuals as well, because of this principle, which says the taxpayer has access to treaty benefit only if, at least in one of the contracting states, he is liable to full or comprehensive taxation. What is full or comprehensive taxation becomes a subject matter of debate. And in countries, particularly my country, who is liable to tax also becomes a subject matter of interpretation. Coming to the physical presence test, again, this is a growing phenomena. I didn't see mention of this notion of stateless income. Many of the domestic laws are moving to address the situation of stateless income. And there are a variety of reasons for that. One, the principle that I just described, whether you're paying full or comprehensive taxation or not. Second, also certain countries are finding it extremely difficult to implement the concept of place of effective management. So if you need to invoke the place of effective management, you'll actually determine the movement of this individual who is the center of control and management. And it is this individual whose movement will determine where the place of effective management and control is. I asked this question to many, many countries. If you just look at the diaspora, the huge Chinese and the Indian diaspora, domestic law of many of these countries uh, actually increased the threshold on number of days to determine the residential status, because they wanted these individuals to come and set up businesses and enterprises and invest in their country. We are now seeing a reversal in the trend. So India changed the 190-day rule to 180 days for non-resident Indians. And in 2021, it went back to 120 days because it felt that people were misusing the 183-day rule, shifting to tax-free countries and not paying taxes, and hence the threshold was brought down to 182 days. What constitutes employment? Svetislav, excellent presentation. I just wanted to add, on a more lighter note, in India, a lawyer can never be employed because under the Advocates Act, yes, he has to be practicing independently. So does it mean all lawyers are not employers? I think you touched on a very important aspect, which is the labor law. Again, if you look at the history of labor law in many, many countries where the civil society believed that labor as a class of citizens were exploited, either from a labor condition standpoint or from an employment benefit standpoint, pension benefit standpoint, industrial disputes, unionization, so on and so forth. All of these definitions and none of these definitions apply in the context of tax. At least in Commonwealth countries, we look at the strict employer-employee relationship. So it's very clearly a set of 8 to 10 principles that will determine whether the relationship is of a principal or an agent or an employer and the employee. I liked the concept of moral character of labor law, a term that you used, and I think it's very, very relevant. Third, Carolina, artist and sportsman. I was just looking at some treaties, and I felt that the treaties used very interesting term. Artist or athletes, entertainer and sportsman, sportspersons. They've used sportsmen, but they haven't used sportswomen. So wherever it's sportsman written, I don't know what to interpret of that. But very interesting definition. I guess, I like the reference you made to the VAT law. So I think there is sufficient guidance that's available. Who's a sports person, who's not a sports person. So if a professional doctor who's trained as a dermatologist, is he or she exercising his employment in the capacity as a professional doctor? It depends. If he or she is giving skin treatment, yes. Cosmetic surgery, yes. But if it is beauty services, then no. So I think it is the context in which the sports person is performing the service. We had many interesting situations. Cricket is a very popular game. Over 1 billion people watch a cricket match, and the Aussies and the English cricketmen, they just don't come to India to play cricket, but they do everything from promotion to acting in movies to various things. And interesting questions have come up. Are they actually the income that they derive from those sources other than playing cricket? Is it income coming from sports and hence entitled to treaty benefit, if any, or domestic law benefit, if any? as a sports person. And clearly the Indian courts have been taking a very, very strict view of that. It's a different story that we have classified some models as artists as well, but that's for some other day. I also feel that the entertainment and sports will see a lot of changes, particularly in very populous countries where entertainment and sport is multi-billion-dollar industry. We always joke about Hollywood moving their headquarters to Mumbai from Los Angeles, but I think given the amount of eyeballs that a Hollywood movie attracts, we are not very far away from that. On Grega and Luka on social security, excellent presentation. We often, as tax professionals, tend to ignore the non-tax aspects of employment. The e-pass technology, I think a whole lot of presentation focused on EU, but the part of the world that I come from is going to see a virtual revolution on social security for a host of reasons. We're still not like borderless as EU, but hopefully in future it will happen as infrastructure develops. The movement of labor, migrant labor, will happen. There is very limited e-governance in that part of the world, and hence availability of data has become a challenge. But thanks to COVID, this tracking mechanism for movement of people has become a very, very common exercise. So we will see a lot of evolution. Projects such as the Chinese Road and Belt project also will throw its own set of challenges on migration of people and labor as well. So I felt you interestingly mentioned about social security contribution. India has a concept of totalization agreement. So I don't know if this concept is popular, but the totalization agreement ensures that the dual social security contributions does not kick in, and this is very important for situations of labor. Our information technology industry has thrown up its own set of challenges. We just don't have people moving for employment. We have people moving for what is called on-site services. And we are not talking about few thousands. We are talking about few million of people moving away, barring the COVID times when the airlines were not operating. And we are again back to that. So I think I just wanted to give you a non-EU perspective feedback as well. You will see many of these challenges on social security far more pronounced in the future in that part of the world, as you're experiencing in EU as well. Those were really my comments. Pasquale, over to you.
With some very fast comments on my side and then the closing. Yeah. Let me do the final wrap up with some very fast comments on my side and then the closing, because I understand that you have already been enduring this day with this interesting conference. So I want you to get ready for the beautiful parts of the evening where you can enjoy together. So I learned from Giorgio about the research that he has done in preparation for this conference, and I wonder whether it could also be an option to start thinking about changing the very function of Article 4 in tax treaties to the extent that we do we go in the direction that he has suggested, with potential repercussions on the entitlement to treaty benefits, but also understanding how we would get into the tiebreaker rules. As for Svetislav, his comments are certainly showing that there is a need not to ignore the what is in between employment and the self-employment or business income. The point is that if we create a third category, we make things more complex. And the issue is that this third category needs to be introduced perhaps also in domestic law and has to be harmonized also with social security, because the point is, what would we do for this third category? How would we treat that third category? And I think that, it was a really nice idea to invite the Slovenian colleagues to be with us, because the links with the social security community is sometimes not so strong. And in real life, those of us who like to do their job across the borders within the European Union find amazing obstacles. It's not just being posted, but it's just choosing to be European and free to do what we want in different places, or being forced not to accept employment and being forced to find other alternatives. Unfortunately, that's for the Slovenian colleagues. You know, in tax matters, the European Commission is very keen to take on board issues connected with business, but is less keen to make some concrete progress in respect of what directly affects the right of what in our community are called taxpayers, that these are holders of rights, and sometimes they are unable to exercise them because of the disparities across the states. Karolina, the final words are for you. And in my case, frankly speaking, I really like the fact of this cross-fertilization between VAT and direct taxes. We should not have separate ghettos, and we should understand that there are separate contexts. But in fact, we have common problems. And the common problems that I've seen today in this session are also called neutrality. And that's an evergreen of international taxation. Because for years, decades, and centuries, we have been seeing that whenever there is a lack of neutrality, then the behavior changes in a way that it's non-desirable, or it's just because you pay less taxes. And neutrality has to be coupled with fairness. We've been discussing in this session about the issues of tax nexus, because essentially that's what we've been discussing. And we have been seeing that it is our task as members of the academic community and also as practitioners, it is our task to discuss them. Rome wasn't built in a day. Sorry for making an example related to Italy, but of which I am a proud national. But the point is still, I have a perception that over the past couple of years, there has been just a rush in trying to force reforms in without properly discussing their pluses and cons, and pluses and minuses, pros and cons. And I think, today with this Belgrade event, we understand that there are issues which arise in theory and practice, and that before passing something through, we should thoroughly discuss and analyze them. And in the League of Nations about a century ago did the same. And I think that this is an important message. We need to change, we need to make the proper change, and we need to be inclusive in making this change and discussing it all together. So I've learned a lot, and I expect to learn even more from the book that will come out from this conference. As I said, I am only virtually with you, so I will miss the beautiful evening that you will be spending together. But bear in mind that tomorrow there is some more work to do. Tomorrow you will have some more minutes to sleep, so you have to be back at 8:45. Thanks very much to Professor Kostić for bringing us all together, and apologies for not being with you. Congratulations to all the speakers, and I list them in the order of performance, starting by Giorgio Beretta, Svetislav Kostić himself, Karolina Tetłak, and then the colleagues from Slovenia, and whom I've only met today. So it's GregaStrban and Luka Mišič, and to our commentators, Marco Felder and Ignacio Gridilla. Thanks very much also to my patient co-moderator, and I wish you a pleasant evening. Thank you.